Today is the 6th of June in 23. Today we're going to talk about some subjects that came up to us from viewers. One, we're going to talk about lien releases. This is both for vehicles and real estate, how to release a lien, remove a lien from an asset, how to get lien release and letter of non-interest documentation, even if there's money owed, how to remove the encumbrance from the asset. We're also going to talk about probate fraud. This is a growing area in our investigative division where when an estate is being distributed from a deceased person, look, there's many hands in that cookie jar. They're trying to get the assets, the bank accounts, the real estate, the vehicles, and you'd be surprised on who is trying to get money that maybe doesn't deserve it. Another thing we're going to talk about is demand letters. When you have a dispute with somebody, when and where a demand letter can be used, and can you do it yourself? Is it something an attorney needs to do? Is it something that you have to get professional advice on? We're also going to talk about a new type of escrow fraud. It's been kind of bouncing around for a couple years, but it's growing lately, and some FBI data is showing that it's not abating. People are losing hundreds of thousands of dollars, sometimes their entire nest egg that they needed to buy their new house is gone, and they lose their house, they lose their money, and how to prevent that. If we get some time at the end, we may touch on mediation once again, but let's first talk about lien releases. When we have a vehicle or a piece of real estate, many times a lien can be placed against that asset. Some of the liens are voluntary. If you get a mortgage on a piece of real estate, that's a lien. That's a voluntary lien. You voluntarily put that on the property, so the bank would lend you the money for it. If you buy a vehicle and you borrow money when you buy it, you go to a dealership, you buy a new Ford Mustang, and you agree to make payments on it instead of paying cash, the bank, the lien holder, financial institution who I guess gave you the money or lent the money on it, they are going to put a lien on that title. They're going to put their name as a secured lender, so that way you can't just run off of the vehicle, stop making payments, and they're out of luck. They're going to have a claim against that collateral. So how do you get that removed? Well, first of all, if you pay off the lien, then it's supposed to go away, right? Well, maybe not. On real estate, when you pay your mortgage off, the mortgage company, the lien holder, normally will file a release of lien, and they'll put it in the land records that erases that original lien document, that lien recording. Land records are a little different than titles to a vehicle. Land records are kept in deed books at the county recorder's office. That deed book is going to have all the documents pertaining to properties, mortgages, transfers, liens, lien releases, maybe sometimes easements. So if there's a lien recorded against the property, you want to get that lien release, or release of lien that clears it off. What about car titles? Well, here's where car titles gets tricky. Let's say you have a car that you buy from a dealership. If you pay cash, they're going to give you a title like this one, right? If you borrow money, they are going to not give you the title, but it doesn't mean the title doesn't exist. The title is still printed by the government agency, Department of Motor Vehicles, whoever gives titles in your state, and they will mail it to the bank that lent you the money, mail it to the lien holder. And they will not only hold the title, but their name is printed on the title as a secured lender. And more importantly, their name is in the title records at that DMV. The name of that bank is filed, recorded in that title document, in that title system. So what happens when you pay off your car? You get a 4-year loan, you pay $482 a month for 4 years. At the end of the 4 years, you pay your last payment, you mail it to the bank. What did they do? Well, unlike the bank for a mortgage, they don't file it with the government agency. What they do is they take that title document that's in their file cabinet, they pull it out, they stamp it paid, they sign it, and they mail it to you. Great, right? You have a paid off car. Well, that's true, but what if you lose that certificate? What if you lose that document, or it gets lost in the mail? Now what? Well, If you go to the Department of Motor Vehicles in your state to have a new title created, a duplicate replacement title, they're going to look it up in the system, punch in their little computer, and it's going to say there's a lien on the vehicle. And you're going to say, wait, I paid it off. I paid that car off. DMV might say, maybe you did, but we sure as heck don't know about it. Why don't they know about it? Because they're not connected to the bank. They don't have a tie-in to the bank. The bank is a separate entity than the DMV. If the bank didn't tell them you paid off your car, how are they supposed to know? And if the bank just signed the title and mailed it to you, that's between you and the bank. The DMV never found out about it. Why would the bank do that? Well, a couple reasons. First of all, it's a lot easier to take that title from their file cabinet, stamp it, sign it, paid, mail it to you, than it is to clear a lien from the title record. In order to clear a lien from the title record, they have to get another document, a lien release document, fill that in, notarize it, sign it, mail it to the DMV with a fee, $40, $50 to clear it off the title. You might think it's only $40, $50, but if they don't have to pay it, why bother? They figured I gave this customer the title. It's on them now. And if you lost it, now you're out of luck. So what does that mean? Well, first of all, if you are watching this video and you have a title in your drawer of your desk, in your file cabinet, and it's a title with a lien on it that you paid off, immediately bring that to the Department of Motor Vehicles, turn that in to show the lien is paid off, get a new title with no lien on it, and clear it off your title record. That way, if you ever lose the title in the future, you're not going to be out of luck, right? What happens if you buy a car that has a lien on it? You find out later. Well, first you got to determine, is the lien paid? You find that out from the lien holder. How do you do it? No, you don't pick up the phone and call them and say, hey, is there a lien? Because most of the time the bank's not going to talk to you, even if they would. At the bank, there is not a lien release department. There's not people sitting around waiting to handle lien releases. Everybody that works at a bank that does car loans is working on files for paying customers, new customers, advertising, payment processing. There's not a lien release people that are paid money sitting around. So you're not going to get good answers. So what you want to do is you prepare that lien release document that the bank needs to sign to go to DMV. Don't let them do it. Don't let them tell you, yeah, we'll do that. We'll take care of it, because they probably never will. But if you print out the form, fill it in, just put a little arrow sticker where you need them to sign and mail it to that lien holder. Now, what does that lien holder have to do? All they got to do is sign it. They don't have to do any work. They don't have to do anything. In fact, we recommend taking this step further. Put a return envelope with your name and address, and even put a stamp on it. So literally that falls on someone's desk. They pick it up, sign it, lick the envelope, it goes out to you. You're good. Why put a stamp? Well, don't banks have stamps? Well, they might, but they might have to go to the mailroom to put a stamp. That's just one more thing you have to rely on that person at the bank to do. And when they get to the mailroom, the person there might ask them, hey, what are you doing? No, you're not supposed to do this. Maybe somebody else is. Could upset the apple cart. Another reason is, many times, even if there's money owed on the vehicle, you can still get a lien release. Now, let's talk about a few things on car loans. You've heard of a charge-off, a write-off. If you have a car that the loan was delinquent and never paid off, and it was a write-off for the bank or a charge-off for the bank, maybe 2 years have gone by and there's been no payments, the bank will put it in their system as a write-off. Well, that doesn't mean it's a payoff. It doesn't mean the loan is paid and cleared. It just means that they never expect to get any money for that vehicle. And they don't have the ability anymore to put it on their balance sheet as a valid asset, as a valuable piece of owned account for the bank. If that loan's no good, they can't count it on their books anymore as something that's of value. So they have to clear it, but they can still collect it. A lot of times they'll sell it to a collection agency, sell it to, some investor for pennies on the dollar. Maybe they keep it on their books, who knows, but they do a charge off or a write off. Now, a lot of people think that automatically means I don't owe the money, automatically means it's off my title. Again, the DMV doesn't know it's a write-off. Doesn't mean your account is zero, but it shows as a charge-off. What does that mean? If you mail a lien release document to the financial institution along with return envelope, the person might pull it up, charge off, sign it, send it to you, right? It doesn't mean they still can't collect the money, but it might mean you get a title for the vehicle where you could sell it or do whatever you want with it. So remember, charge off and write off are two different things. They don't pertain to having zero balance. They pertain to the fact that the bank's not expecting to get any more money out of you, right? So the next thing we're going to talk about is probate fraud. But let's take a quick break, reset, and see what is the current state of affairs with people who are deceased and have their estate distributed improperly. So when a person dies, all of their assets are put into what's called an estate. And that estate is the inventory of everything they own, their bank accounts, their real estate, their vehicles, their corporate assets, intellectual property. There is 11 or 12 different kinds of assets a person can own. And when they die, obviously when you're dead, you can't own things anymore. They have to go somewhere. They have to be distributed. In fact, banks can't even keep accounts open for a dead person beyond a certain period of time. How is that done? Well, normally if there's a will, the will, last will and testament, will give instructions to an executor, that's the person who handles the will, to pass along these assets, pass out these assets. The executor doesn't have to be somebody who gets any assets. They could just be a person that's in charge of sprinkling them around to who's supposed to get them. Sometimes they get, heirship and they get some of these assets. So the will describe, okay, Sally gets the house, Bobby gets the car, Susie gets the bank account, whatever, right? But that's a trust situation. That assumes that the executor is going to pass it out the right way. And more importantly, it assumes that the executor, the person who does this, knows about all the assets. They're aware of all of them. How are they going to know about them? Well, maybe they're one of the children and they should know. Maybe they're the attorney that has a list. However, it's very common when a person dies, or maybe even right before they die, if everybody knows, for some of the people who are supposed to get assets, or maybe they're not, will start to try to divert some of this value to their benefit. For example, if there's an old classic car in the barn, maybe grandson Bobby moves that car and puts it somewhere else. Maybe if there's a piece of jewelry that's worth some money, maybe the cousin takes it and sells it for cash, right? Minor things. Maybe if there's a bank account, a CD that's sitting there that maybe, the brother doesn't think anybody knows about, they cash it in, right? Or maybe they don't tell the executor. That's called probate fraud. Everything belonging to a deceased person is supposed to be properly distributed and itemized by that executor. People get greedy. They don't want to wait for the executor. They don't want to get their fair share. They want to get more than their fair share. So they'll do probate fraud. The amount of fraud on a case can get into the hundreds of thousands or even millions of dollars. The sad part about probate fraud is, unlike divorce settlement fraud, two people that are in conflict with each other, probate fraud are people who are in the same family and they're supposed to be relatives. They're supposed to respect each other, but people try to slide little things off the table so they can get more money for themselves or more assets for themselves. Every single time we do a probate fraud case, we find assets that are distributed improperly. So how can you make sure that this does not happen to you? Well, first thing you want to do is you want to run a good asset search on the person who is deceased. You want to make sure that you have a list of all the assets. Don't take the word of the executor, heirs, relatives, first of all, they might not know. Genuinely, they might, not trying to hide anything. They just might not know. Second of all, you might have one or two people that want to keep something secret that they knew about. Maybe you didn't know that grandpa had the coin collection. Maybe you didn't know that he used to own a business. Maybe you didn't know he had Coca-Cola stock certificates in his nightstand, right? You want to do a proper asset search to know what are the assets owned by that person. So that way, there's a proper accounting can be done. Once you have the asset search, you can compare that to the distribution through the will to make sure it's done properly. If you are a relative of a deceased person or even somebody who's close to them and you're not sure if you should be getting assets, make yourself known to the executor. You can file a notice, send them a letter. You may want to get legal advice. Remember, we're not attorneys. We can't give legal advice, to find out what your rights are about finding the asset distribution to make sure it's proper. Also, this applies to life insurance. You want to make sure any life insurance policies are distributed. Sometimes when a person dies, one party will try to cash in that life insurance policy, or it might not be known. So be aware that the death of a person can open up a can of worms for a free-for-all for everybody trying to grab their assets. They figure, well, Grandpa Joe is not alive anymore, so he's not going to care if I steal from my cousin, my sister, another sibling. The will, last will and testament, is exactly what it sounds like. It's their will. Their will be done. Like, they want this to happen. So make sure you're honoring that person by making sure the assets are distributed properly. Get a good asset search. And make sure you're not being defrauded by the person. Related to fraud, we're going to talk about another subject, which is escrow fraud. Let's take a break. Think about the next subject, which is an insidious type of fraud that has to do with real estate transactions. So what is escrow fraud? Escrow fraud is when a real estate transaction is pending and the buyer is communicating with the title company to get all their ducks in a row, get all their paperwork ready. And that communication usually takes place a lot of times by email. Some is phone, some is email, some is in person eventually, but it usually starts by email. How does that process work? Well, here's what happens. When you buy a house, the first thing you do is you sign a contract with the realtor. Usually it starts with an offer, a counter offer, back and forth. Once all the negotiation is done, that last version of the offers becomes the valid contract. It has the price, the terms, the conditions. It's usually a standard form that realtors have that you just fill in the address and the price and everything else. Great. So that contract is signed. The next thing that's done behind the scenes, unbeknownst to you, that contract is sent to a title company. This title company is going to do what's called escrow. They're going to collect all the things from you, the buyer, from the mortgage company, from the insurance company, from the HOA, if there is one. They're going to get the deed from the seller. They're going to get all the details, put it all in a pot, and then distribute it to where it goes. It all comes in from certain people, goes out to other people. What do we mean by that? Well, if you're buying a house, let's say for $700,000, $700,000 comes in from the buyer and goes out to the seller, right? But you don't want to just write a check to the seller for $700,000 and hand it to them, because what if they don't give you the deed to the house? Now they can run off with your $700,000 and you're out of luck. On the other hand, if you're the seller, you don't just want to sign over your deed and hand it to the buyer and hope they pay you, because once you hand over the deed, it's not your house anymore. So the escrow company takes those two things, make sure they have them both, make sure they're both good, and then give them to the other person. That's the oversimplified answer. But it's more complicated than that, because all the money for a purchase usually doesn't come just from the buyer writing a check. Usually, if it's a $700,000 house, maybe they put down 20%, 140,000. So they write a check for 140,000, and the rest comes from the bank lending the money on the mortgage. So 560 comes from the bank, 140 comes from the buyer. That goes into a pot. Once it's all there, the deed comes from the seller, and then it goes to the seller. But usually the seller has a mortgage too, right? Maybe the seller has a mortgage that has 300,000 owed on it. So the escrow company takes the first 300, pays off the mortgage company, and then gives the rest to the seller. See how it gets complicated? There's a lot of moving parts. Plus you have real estate commissions, insurance, retentions, a lot of other payments. Now, that being said, the most important part is when the buyer pays the money, they usually don't just write a check. Most title companies don't take checks, because if they took a check for $140,000 and that check bounced and they passed the deed over to that buyer, they're now on the hook for that $140,000. They have to come out of pocket to pay the seller because they're responsible for the escrow. So no, a title company is not going to take your personal check. They're not even going to take a bank check or certified check because those can be forged. Those can be, there's instances of fraud with certified checks. So what the title companies have gone to is a system of wire transfer. You have to wire transfer the money to the title company. Once they get it, now you know it's good money. It's safe, it's secure, it's in their account. Because wire transfers are irreversible. Remember that. That's going to be an important factor. So the title company sends you an email that says, hey, Joe Schmo buyer, your total you need to come up with is $142,000.12. Here's the wire transfer instructions. Here is the here's your bank statement with your account number and routing number. Wire the money there. So you dutifully run down to your bank. You give them the account number. You give them the wire transfer number, and you send the money to the title company. You're good to go. $140,000. Boom, they have it, right? Wrong. What has happened, unbeknownst to you, is some hacker, some scammer, some fraudster has intercepted the emails from the title company or the realtor or the insurance company, somebody, and misrepresented themselves to you as the title company. They send you an email that looks like it's from the title company. It has their logo. It has the name of the person, has their phone number, has all the information, has their website. But in the email, it says, here is the account number and routing number. Send the money here. It's not the right one. It's their account number and their routing number. So now you just wired $140,000 to some scammer that's not the title company. That money's gone. How do you find out? Well, a week later, the real title company calls you and says, hey, where's our money? And you said, I already sent it. No, you didn't. Now you start panicking. Well, how did the escrow company become hacked? Well, you got to remember, hackers can easily hack an email. They break into your system. They monitor your Wi-Fi. Realtors are notoriously vulnerable because they're not a high financial institution. They're not processing lots of money. The realtor is just a sales organization. A lot of realtors are private individuals. They work from home. They work from their laptop. They work at Starbucks. Their email is easy to hack. And all they have to do is see an email from a realtor that has a contract in it, a closing instructions in it. 122 Main Street, $700,000, buyer and seller's name, title company. That's all they need. Once they have that, they can do the rest. They can make a fake website that looks like it's a title company. They can make a fake email. All they got to do is observe the email coming out of that realtor's email account, right? So now you sent your money. It's gone. Well, a couple things. First of all, there's an easy way to prevent it, and we'll talk about that. And there may be a way to get the money back. See this website name on the screen, verifyescrow.com. This is not something you have to pay for. It's not a service. We're not trying to sell anything. We're not trying to charge you any money. It's instructions for how to avoid losing your money to an escrow fraud. Basically, what you do is when you get your wire instructions, you do two things. You call the actual title company and you read it to them, the numbers you have. Make sure they say it's correct. But don't just take it for granted that that's right. Sometimes the hackers will be a little more slick, a little more advanced, and they'll actually put a fake phone number in the email. So when you call them, they have somebody that answers the phone and confirms it. Take it a step further. You're talking hundreds of thousands of dollars. So don't feel bad that you're doing overkill. When you go to your bank to wire transfer the money, wire transfer a very small amount of money, $50, $100, $200, whatever it is, a small amount of money that you can afford to lose as a test transaction. Send it by wire. Then go to the title company in person or contact a realtor or something and verify that they actually received your test transaction. Make sure you're actually talking to the real title company. Maybe look them up on Google Maps, not on Google, because people can make fake websites on Google. Look on Google Maps and click on the listing and get the phone number from there and call them. If it's an attorney, a lot of times escrow is done by attorneys. Click on Google Maps, find the attorney website, call them. Did you get the $180 that I sent you as a test transaction? Yes, I did. Great. Thanks for telling me. Then you go back to your bank and send the rest of the money, but don't give them a new account number, a new routing number that you have written down somewhere. Tell them to use the exact same one that you used before, because you know that one worked. Even if you say, well, I'm using the same one from the paper. Maybe you messed up the papers. Maybe somehow you printed out the wrong one from the scammer. Tell your bank to send the full amount using the same wire instructions you had last time. That way, you'll avoid sending it to the wrong place. It's easy to avoid. If you're a realtor, if you're a title company, on that website, Verify Escrow, we have forms that you can give to your buyers and your sellers with these instructions, exactly what to do. Send a test transaction. We're not charging you anything. It's not anything you got to pay for. The only thing you might have to pay for is if your bank charges you a fee to send a wire, $5, $10, you might have to pay 2 fees instead of 1. Big deal. It's like a $5 or $10 insurance policy, right? So avoid the wire. What if you are a victim of an escrow fraud? What can you do? What you can do is you can try, if you catch it early enough, to contact the FBI and the IC3 and do what's called an FKSS, financial kill system. And it can kill a transfer if it's caught early enough. That's beyond the scope of this video, but you can look that up, get with your bank. You're going to need to really scramble and do this quickly and get some powerful people involved to do financial kill system to kill that transfer out and put the money back in your bank. But that's something that you can look for. So enough on escrow fraud. Again, if you have questions, put it in the comments. Let us know if this is something that's helpful. Next, we're going to talk about sending out demand letters if you have a conflict and maybe how that might affect mediation. For a moment, we're going to take a quick break. You'll see a video about how to reach an actual human. You can see our website, Actual Human, to talk about these things directly. You'll have the undivided attention of a licensed certified expert in many fields, financial fields, legal fields, investigations. So if you're having trouble getting through to a real person at a company, which is almost impossible anymore, this is a way you can do that. So we'll take a quick break, take about 30, 40 seconds. On the other side, we'll talk about sending out demand letters and how that might be a way to alleviate a serious conflict or legal litigation.
Are you tired of automated systems and chatbots when you need assistance? Experience actualhuman.com and connect with real professionals, not automation. At actualhuman.com, we bring you a network of professionals who are excited to answer your questions and provide guidance. Getting started is easy. Let us show you how. Here's how it works. Step 1. Select the best date and time for your video call. Step 2. Describe your situation and the areas you're looking for advice. Step 3. Connect one-on-one with an expert and get the undivided attention that you deserve. Experience the difference. Visit actualhuman.com today and schedule your professional consultation. Actualhuman.com. Expert guidance from real people.
Hopefully that gives you some good info. So let's jump right into the next subject, which is sending out a demand letter. If you are in any type of dispute with another party, obviously you can end up going to court and fighting it out, do litigation, do a full lawsuit. Great. But as you know, not only is it going to cost you a lot of money, but most courts now are backed up many, many months. Some, if you go to full trial, you might be 2 years out from getting a trial. In most cases, if the other party is properly notified of what you're asking from them, you may actually get some results. So you can actually create a demand letter. Now, granted, you might want to get some good legal advice about the wording and what to say, because you don't want to say something that's going to get you into trouble. You don't want to threaten somebody, blackmail them, mistreat them, abuse them. But if you very clearly state what it is you're looking to do and what the resolution is, and you're reasonable about it, right? If you're being ridiculous or being mean or you're trying to get more than what's coming to you, you may not get a good result. But if you're very clear and reasonable and honest, let emotions come off the table when you send a demand letter, many times you can actually start the process of resolving the case. As a party to a dispute, I get it. You want to win. You want to conquer. You want to prove yourself right. But many times, if you stand on principle, you might not prevail on facts, even if you're mostly right. Remember, in any dispute, there is some version of right in both people. You may be 90% right, but they're probably 10% right. And they're not going to let go of that 10%, at least until it's been recognized. So if you come into a demand letter with all kinds of high horse and superiority complex, you may lose out because you stood on your pride. Being diplomatic can help. You don't want to give away the farm. You don't want to let the other side win if they're not deserving of it. But just remember that there is psychology involved with this. There was an old study that they used to do where they would put two people in a room and they would tell one person, look, we're going to give you $100, but you only get to keep it if the other person in the room agrees to let you keep it. So you have to offer them something to make it fair. So you would think, well, gee, if I have 100 and I give them 20, they get free $20. So of course they would agree to it. They found that in most cases, it took more than 20% of that payment to make the other person agree to let you keep the free money that was free for both people. Most people would rather let everybody walk away with nothing if they felt like they're mistreated. Some people want to have half, and they won't budge unless you give them half. So that psychology comes into play with litigation. So remember, when you're doing a demand letter, you're doing any kind of settlement negotiation, the other side has to feel like they were treated properly. And that is very common with mediation. When we do, mediation events, we have to hear the needs of both parties. Look, not everybody's always right. Not everybody's always wrong. But mediation is something that includes hearing both sides of the case and making both people realize what the risks are. There's risks to trial. There's risk to litigation. And the risk might be unfair. It might be something that causes both people to get less than what they deserve. But what you deserve is a lot of times not what you end up getting. It's what you think you're going to get. If you are in some type of a conflict, starting with that demand letter, or at least some kind of communication, is a good thing. Remember, demand letter is just a phrase. You don't want to sound like a demand. You want to sound like a request. Very clear, very straightforward. But if you just start drawing lines in the sand, sometimes people will just be ridiculous and unfair just on principle because they don't want to feel like they were bulldozed by you. So a demand letter is a good way to start that process. Any type of official event process, whether it's a lien release, a lawsuit, an escrow, has resources available to you as a consumer, which can make the process smoother for you. You want to get with a good team of qualified experts. You don't want to go this alone. Whether you hire a full-blown attorney to represent you, you can do that. Whether you use free resources, whether you tap into experts that are qualified in different fields, anything that's important enough to where it's, costs more than a couple $1,000s, even a vehicle transaction, real estate transaction, lawsuit, dispute, divorce, liens on assets. You want to make sure that you're not flying blind, that you're not doing something that's a mistake that either costs you money, puts you at risk, or doesn't give you all the advantages of what you're trying to accomplish in the first place. Those resources are out there. Most of them are free. You can access free advice dozens of places. You can access professionals. The biggest mistake is not using what's called AAI, all available resources. AAR, all available resources. And if you do something that's of any consequence, that has to do with a lot of money or a lot of personal risk, getting good advice from professional, even with insurance, is going to put you in a place where you're not going to have the highest probability of losing out. Appreciate you watching another episode. Put your comments below to let us know what you'd like to hear us talk about next. If you like this kind of content, hit subscribe. We normally do many videos every week that talk about different professional and expert subjects. We'll leave you with, again, a mention of how to be able to access live, actual human beings that are professional, certified experts that can help you with these different subjects that are important. So you're not at the will of a salesperson trying to sell you something or getting chronic voicemail or emails or AI chatbots. You're actually talking to a person. See you on the next episode.
Are you tired of automated systems and chatbots when you need assistance? Experience actualhuman.com and connect with real professionals, not automation. At actualhuman.com, we bring you a network of professionals who are excited to answer your questions and provide guidance. Getting started is easy. Let us show you how. Here's how it works. Step 1. Select the best date and time for your video call. Step 2. Describe your situation and the areas you're looking for advice. Step 3. Connect one-on-one with an expert and get the undivided attention that you deserve. Experience the difference. Visit actualhuman.com today and schedule your professional consultation. actualhuman.com. Expert guidance